So the question posed really, and the question I hope you're going to get some information on here today is, do I need to seek the customer's consent before I use their personal data? So we intend to record the webinar and it will be available on the Data Protection Unit pages in eZone. So that's the landing page. When you click into data protection, the middle box there has training and awareness information, and you'll find the webinar in there, along with a frequently asked questions sheet on the whole consent issue. So we'll get that there by the end of the week. Right, as an overview, there are 4 broad sections to the presentation. I will just give a bit of background and terminology. Then I'll go into the legal basis of processing and why is that important. Then what does GDPR say about consent? And then should we be using it or not? So to help understanding, first of all, I'm just going to go into the background and terminology used. So what we're talking about today here is consent in using personal data. Personal data is what is mentioned in data protection legislation. It's all about the use of personal data. It's not just any data, it's personal data. So then what do we mean by personal data? So there's the obvious things like the name, the address, email address, any contact information, images you may find on CCTV, photographs, any of the really obvious stuff that most people would recognize as personal data. Then there's other data that people mightn't recognize, but it still is personal data. And that is application numbers, where it's linked to an individual's application, herd numbers, even though some herd numbers have more than one individual behind them, but it's still personal data to them. License numbers, registration numbers, anything which is linked to an individual. So you're going back to the individual and it's their data. And then there's another category which often is overlooked and people don't see it as personal data. But if you are giving out details and it is at such a level that, for example, you're giving details of farms in a region and it's at a very local level that, for example, you're identifying the farmer in the data that you're saying because the data is showing it at such a narrow level. For example, if you're talking about all the types of farms in Cork, and you might give a bit more information than that, but when you break it down, there's only one duck farmer in Cork. So the information you're giving would be very specifically identifiable to them. So you've got to look at the context that you're giving the data to see, could I actually pick out an individual out of this? And if you can, then that's their personal data. And you need to consider data protection legislation. And am I doing the right thing? And am I allowed to give out that information in that context? So one very simple example I've mentioned here on the bottom is that if there were, if an area department, for whatever strange reason, was doing a survey on shoe sizes of the staff of the department, and they came to Data Protection Unit and said, well, shoe size, that's not personal data, is it? It all depends. You've got to look at the context. If they're going to hold a spreadsheet where one column is the name of the person and the second column is their shoe size, then both of those pieces of information is personal because you can identify whose shoe size it is. So if they stripped away the names, deleted the names, and just held the shoe size information, then that is not personal data. You cannot identify whose data it is. But if they kept it next to the name, it is identifiable information, and then it is personal data. So the context of what data you're holding and what it's being held with is very important to consider what is personal data. So then what is meant by processing? The data protection legislation and all the guidance in the area talks about the processing of the data and that what you can and can't do when you're processing the data. And some areas might think they're not actually processing data because once they have it, they don't actually do anything else with it. But the definition of processing in GDPR is actually very, very wide. So just to go down through it quickly here, it includes any operation performed on personal data or sets of personal data, so groups of personal data, whether it's by automated means or not. So that means whether it's in electronic systems or in hard copy. And it includes collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment, combination, restriction, erasure, or destruction. So processing of data covers absolutely everything you can do with data, or pretty much. So in short, my recommendation is, if you have the data at all, if you have personal data or have access to personal data, you are processing it. And what legislation are we talking about here today? Very quickly, we're talking about the GDPR, which came into effect in May 2018. There is the Data Protection Act, the Irish Data Protection Act, which also came into effect in May 18. The Law Enforcement Directive, which is an EU directive, which relates to the processing of data for criminal investigations and prosecutions. It's very similar to GDPR, but it just relates for the purposes of criminal investigations and prosecutions. And the Data Sharing and Governance Act, 2019 Act, but it was only fully commenced in December 22. And that refers to processing of personal data for sharing across the public sector. So who's responsible for processing the data and who needs to be getting this right? Well, it's the division who has the data, it's the division who holds the data is going to be the one that processes them. Even if you're not the division that initially gathered it, if you're just getting a copy of it or part of it to use, to combine with your own data or to use for another purpose, once you have it and you're holding it, you're going to be responsible for that data. So you need to know that you're doing it properly. The head of division is ultimately responsible for data protection in their units, but they will develop that down through the staffing grades. So if you're handling data and you're making decisions around it, you're responsible. The data protection unit can give guidance and assistance, and we're free to take any questions at any stage if you get them to us, but we cannot take on data protection responsibilities for the department because we don't have the data and it's not our data to make decisions on. So we will only be giving guidance to the business units, and they're the areas that make their own decisions. Okay, consent is one type of legal basis in GDPR. So what do I mean by that? What is a legal basis and why do we need it? GDPR says that in order to process personal data, you need a legal basis. And the reason that is a basic requirement in GDPR is that the whole point of the GDPR was to ensure that organisations weren't just gathering personal data and doing whatever they wanted with it. It is narrowing their permission as such as to what they can do with personal data. And the first and the biggest hurdle that they must jump over is they have to have a legal basis to process the data. So that is, you must have legal permission to process the personal data. So Article 6 in GDPR outlines how you can have a legal basis or what a legal basis looks like. So going down through them, consent is the first one. Consent to the customer is where they give agreement to use their data. So that is one type of a legal basis. Contract is another one. So if you have contracted with another organisation or company for them to supply a service to you, and you need to give them your personal data or other customers' personal data for them to carry out that service, that is a contract. A contract is in place then, and therefore that is another legal basis. So that is okay legally to do that. A legal obligation is the next one. So legal obligation is where you're legally obliged to do something. So the department carries out the vast majority of its functions and operations under a legal obligation. There's legislation in place, and that is what the department is trying to do. They're trying to carry out the functions under that particular piece of legislation. So in order to do that, in a lot of cases, we need personal data. We can't do it without it. So for example, payment schemes, for example, registrations, anything like that where we're gathering personal data. There is usually legislation behind that dictating what we must do. So legal obligation is our legal basis there. It's not consent, it's legal obligation, because what we are doing is in line with legislation. Vital interests is another one. However, it doesn't come into operation for our department. It is more around the use of data for medical or life and death circumstances. The processing of data for a task carried out in the public interest or exercising our official powers, that can come into play for the department on occasions, but you must be able to show where those powers or that function lies in legislation. So again, you're coming back to the underlying legislation. And legitimate interests. That is used in the private sector quite a bit, but it is not something that's open for public authorities to use. So the reason legal obligations highlighted is because that is the legal basis the departments use in about 90% of our processing. The reason we handle and make decisions around personal data is because we're legally obliged to carry out a function, and that function is in legislation. So the legal basis used in the majority of cases, as I mentioned, is legal obligation. Also, the legal basis we use in some cases, or in a lot of cases, can be contract. So it's when the department enters into a contract with a company for goods or services, and we must give over personal data for that to be carried out. Okay, then getting into consent itself. So consent is one legal basis, but you can operate under any of those legal bases that I have listed earlier. You don't need consent all the time. If you have one legal basis to process personal data, you can go ahead and do so. So, but the rules around consent are, if you are going to use it, you must ensure that it was freely given. So there could be no strings attached. If you're asking someone for their consent to use their data, it must be absolutely up to them as to whether it's yes or no. They can't be forced to say either yes or no. It must be specific. You must be very clear about what you're asking them to consent to. No ambiguity, no fuzzy language. They need to be fully informed about what they are consenting to. So they should be told the full story about what will happen if they say yes to this. And it should be unambiguous. Again, very clear, no ambiguity. They need to be clear what they are giving consent to. Consent must be freely given, as I mentioned. This is one that can be difficult to satisfy, let's say, if the whole legal basis is ever scrutinised at audit time or by the Data Protection Commission if there's ever a complaint. So if you say your legal basis was consent, they'll want to know how was it freely given. They'll want to see where you asked for consent and where the customer gave it. What is the language? What is the information that was given at the time? And for example, you often see it if you are signing up to marketing emails. They will ask, do you wish to give your consent to it or not? Should be a choice, yes or no. It's not considered valid consent if you don't have that choice. And you must be able to opt out later. So the marketing emails, you will often see the unsubscribe button right down at the very bottom. So they must legally give you an option to opt out of that later if you wish. So consent must be a clear, affirmative statement. So you must do something. You must tick a box. You must say yes to show your consent. Silence is not consent and will not be considered valid. So you must be able to see where the consent was given. Think about it from an audit perspective. How are you going to show that the customer gave consent? It must be clear and it must be recorded. You must be able to audit it. You must be able to withdraw consent later and again show when that happened, where it happened, where can I see documentation that actually documents this and shows it. You need to provide information at the time you are seeking consent about how it can be withdrawn later on. And the process you're setting up must be prepared for that withdrawal of consent. So if you're asking someone, do they consent to use the data in a particular circumstance? If they come back 6 months later and say they're withdrawing that consent, you must be able to deal with that. You must have your process set up that you can either stop doing what it was they have consented to, or you can shut down the consent and just that process no longer happens. So consent for the use of data should never be grouped with other things that you're asking your customer to agree to. So if you need consent for the use of data, it should be listed on its own. Do you consent to the use of your data for X, Y, and Z? Yes or no? It shouldn't be grouped. For example, you shouldn't say, I agree to the terms and conditions of this scheme and to the use of my data, and one box at the end that they tick. That will not work as valid consent. It is grouped. They are unable to say no because it has been grouped with the terms and conditions. It needs to be a clear choice. So do you agree to the use of your data, yes or no? And it needs to be a real choice. It can't just be there for the optics. It absolutely needs to be real, that they can say no as well as yes. So getting on to GDPR then, what does it say about consent? Well, it says it absolutely must be freely given, and it is spelled out in Article 43. So it says, in order to which your consent is freely given, consent should not, sorry, no, my view boxes are blocking that. Consent should not provide a valid legal ground for the processing of personal data in a specific case where there is a clear imbalance between the data subject, so that's our customer, and the controller. That would be the department. The department is gathering in the data, so we're in control of it. So in particular, where a controller is a public authority, and it is therefore unlikely that consent was given freely or was freely given in all the circumstances of that specific situation. So what is Article 43 actually saying? So Article 43 is saying that in circumstances where there is an imbalance in the relationship between the customer and the controller, it's unlikely that consent can be given freely. So that is going to, and in particular, it mentions if the controller is a public authority. So that is really pointing out to us that we are not really in a position to be going to seek consent from our customers for the use of their personal data. We are a public authority. There is an imbalance in the relationship. It is viewed as the small customer afraid to say no to the big organization who's gathering the data. And if they're afraid, if they do say no, they won't get the payment, they won't get the license, they won't be able to register. So they're afraid to say no. So that's why it is considered inappropriate for a public authority to go and seek consent from our customers for the use of their data. Now, I would say that doesn't apply in 100% of the time. It all depends on the circumstance, but it does apply, in my experience, in about 95% of the time. So most of the time, it is not appropriate for us to go and seek consent from our customers for the use of their data. Okay, sorry, the slide is slow to move on. Okay, so can I use consent, as I mentioned, as a legal basis to process our customers' data? Probably not, is my answer. You should probably presume that you can't rather than you can. But do I need consent? No, not if you have another legal basis to use. As I mentioned earlier, most of the department is carrying out its roles and its functions based on a piece of legislation. And that is going to be your legal basis. You don't need consent if you have a legal basis in something else, particularly in legislation, which is a very strong one. If it states that the department must carry out a particular function, and in doing that you need the customer's personal basis, then you don't need to go and seek their consent. So if you're not sure, check, but you probably do have another legal basis to rely on. Then in circumstances where it might appear that the customer is giving consent. But you should be clear that they're probably not. It depends the way you ask the question. So if a customer is sending in an application for a department scheme, for example, for a payment or a license or to be registered, they are doing so voluntarily. Yes, it's a choice whether they actually do this or not. But consent is not the legal basis for processing their personal data. The department is still operating under legislation to put that scheme in place and to offer this to the customers. So the legal basis in that case will be the legal obligation, which is based in legislation. So the statements often put at the end of application forms currently can read as, I agree to allow my data to be used in this way. And I'm strongly suggesting that that's not the wording, that's suggesting that consent is the legal basis when it's not. A better option is that I am aware my data will be used for the purposes of this scheme or the administration of this license or whatever it is. Don't ask for permission when you don't need it. It makes it look like you're seeking their consent when you don't actually need to do so. And again, another one where it looks like consent, but is it? So if the department is engaging an outside company to carry out a service for it, and the example I list here is a pretty basic one. It's a printer who is going to get information from the department of a group of our customers. They're going to print up the letters, maybe include some information in the content, and issue those letters on behalf of the department. So we have engaged them. There is a written contract in place with that printers that they're going to do this. So we then need to hand over the customer's name and address and other information so that they can do this. That is absolutely valid that the department does this, and we don't need the customer's consent for that. We are carrying out, or the printer is carrying out the terms of the contract, and we have engaged them in a contract. So our legal basis there is contract, and we don't need consent. So do we ask the customer for consent? No, we don't. We must have a written documentation in place to show that we have a contract in place, both for our own assurance over the contract being carried out properly, but also for audit purposes. You've got to show that there was a contract in place and that therefore that company could handle that data. The customer can be informed about the engagement of that third party, but they don't have to be. The department does not have to inform its customers about all the third party companies that we engage. Once we are doing it legally and have our contracts in place so that that company is handling that data in line with that contract, that's perfectly in order. The customer does not need to be informed. And it is not consent that we are using, or that the company in question is using as a legal basis. Contract is your legal basis in that scenario. So we do not need consent. So other quick ones on, do I need consent when a customer wants their family member to act on their behalf? That is a yes, but I'll qualify it now in a second. Or a solicitor comes in requesting customer data. Again, that is a yes. That's giving out information to third party. But this is not actually seeking consent from the customer to use their data. This is the customer giving authorization for their own data to be used. It's not the department asking for the customer's consent. It is the customer asking the department to give their data somewhere else to another party. So that's actually authorization. Sorry. It's not a consent scenario. It's authorization from the customer instead. But in other circumstances, if another public body, for instance, comes seeking our customer data, and it happens frequently, the guards, revenue, could be local authorities, it could be Department of Housing, lots of different public sector organisations come looking for the department's information. Do we then need to go to the customer seeking their consent? The answer to that is no. The vast majority of these requests will appear into the Data Protection Unit, where we will give advice out to the division who've got the request that they must go back to the requester and ask them what's their legal basis to get this information. So it's a bit like the department needs a legal basis to handle personal data internally. If somebody else wants to get it from us, they must also have a legal basis to make that request. 99.9% of the time, they will have a legal basis. And again, it will be based in legislation. The guards can request personal data for us based in the data protection legislation. Revenue commissioners have their own legislation. The Department of Social Protection has their own legislation. So they all know this and they're used to getting asked this. We do not need to ask the customer for permission in those circumstances. The legal basis is there in legislation and we can release the data. So that if the department has customer data already and we're considering using it to set up a new scheme or a new process, do we need the customer permission then? Do we need consent then? Again, no. But we need to find the appropriate legal basis to use in those new circumstances. And again, there probably is one if you look closely enough. If you can't find it, come to the Data Protection Unit and we might help you. But don't just assume you can go back to the customer and seek their consent. That is probably not in order. Now, the customer often can make a complaint that you need my consent to do this or to do that with my data. Or if you want to share it with another organization, you should be asking me, you need my consent. That is actually a mistaken belief. You can, when they say you cannot share my data or use my data without my agreement, that's incorrect. If there is a legal basis to do so, you can share or you can use that data in that new way. You do not need consent of the customer. For example, the guards seeking the data, as long as they can show where they have a legal basis to get that data, and it's usually in legislation, they can do so, they can get it. Revenue commissioners, CSO, any other public authority, again, we ask them where is their legal basis to receive the data, and then they can get it. We do not need the consent of the customer. So our legal basis is in the legal obligation, it's in the legislation. So very often we will be asking, what's the legislation behind what you're doing? If it's another organisation, we'll be asking them, what's your legal basis? And we expect to see it in legislation. Consent is not the way to go here. You do not go back to the customer and seek consent. We're a public authority. It's in GDPR that consent is not appropriate in the vast majority of cases when to use by a public authority. So don't assume it is okay to use consent. It's usually not. So can I ask for consent to share data with another public organisation? It really depends on the reasons for this and what's going on and why it's been shared, what that other organisation is going to do with it. There might be a legal basis already to share that data, and usually I find that there is, and the other organisation will know where to find it or should know where to find it, so you would ask them to find it for you. So if you're unsure, seek the assistance of the Data Protection Unit. So the final message on this really is consent is tricky. It's very hard to get it right. Usually it's not available to public authorities, and that includes us. So usually we cannot go to our customer and ask them for the consent to use their data. Don't assume you can use the consent of the customer. Don't assume you can go and ask them for consent. They'll say yes because they want to carry on with whatever's going on, and then it's okay to continue to proceed. That's probably not the right way to go about things. Check with the Data Protection Unit if you can use consent before you actually set up any processes to do this, and ask us for help if you're not sure. Again, we have a lot of information on our eZone on data protection generally. In the middle, you'll find the training and awareness section. This webinar will be there with frequently asked questions on consent, and we'll get it up there before the end of the week. So back to our question. Do I need to seek consent the customer's consent to use their personal data? And I would say the answer to this is probably not. It's probably not correct to seek their consent in these circumstances. Usually there is another legal basis to use. And if you're not sure, come to the Data Protection Unit and we'll try to help you find it. That's the final slide with just some contact information on where to go for help. We're the Data Protection Unit, data.protection@agriculture.gov.ie. Staff names are below, a generic phone number there, which you'll get anyone on the unit under. So if there is any questions, you are free to put them in now, or you can come to the unit after this presentation and we'll help you then. Okay, Maura, is there any questions we need to cover?
There's not, Katrina. Thanks for that. I think, look, there's probably a lot in that presentation that you gave. There aren't any questions in the inbox at the moment, but as you say, you know, it might be easier for people if they have something to email us directly in Data Protection.
Absolutely. Yeah, and I'd just say in Data Protection, because we usually need to know the context of your query, if you do have queries, just tell us what's going on. Why are you gathering the data? What do you propose to do with it? Have you got legislation that tells you must do it this way or that way? So just give us a bit of context with your queries and we'll try and help you then.
Okay, that's fine. Thanks everyone. And like I say, the Data Protection Unit, if you have any questions at all on today's webinar or I suppose anything data protection related. Thanks again, Katrina.
Thank you.